So welcome and thank you for joining us today. You are at our Estate Planning 101, What You Need and Who Needs to Know. This is part of our alumni virtual event series. This has been co-hosted by our Office of Plan Giving and GU School of Law. My name is Annette Davis and I'm Gonzaga's Director of Plan Giving. Also, with today being Veterans Day, I would like to just acknowledge and thank all of our military members for their service and wish you a very happy Veterans Day. A couple of house cleaning kind of items we want to go through as we get started. So we are recording today's webinar and it will be available following the event. We will also be taking questions and answers during the last 10 minutes of the session. So please use the chat box to submit questions during the webinar, and that's at the bottom of your screen. And we'll also have a follow-up email that will be providing some helpful resources when the webinar is over. So stay tuned for those. And I am excited to introduce today's presenters. We have first Professor of Law Anne Murphy. She has been with Gonzaga since 2000 after working with the IRS for 15 years. Her courses include tax, wills and trusts, evidence and civil procedure. We also have with us Patrick McNulty. He's an attorney and principal with Randall Danskin. He is a Gonzaga law graduate. His practice areas include estate planning, probate and trust, and trust litigation. In addition, Patrick is a busy man. He teaches as part of our Master's in Taxation program, and classes include tax practice and procedure, estate and gift. So he's extremely knowledgeable also. He's also a graduate of Notre Dame. You may notice a picture behind him, if you can see it in the background. And he also received his LLM in taxation from the University of Washington. So we are very grateful to have you two with us today. And at this point, we have a lot of material to cover. So I will hand it over to Anne to get started. Oh, Anne, we can't hear you.
I'm going to see if I can unmute her real quick. It doesn't seem that I'm able to unmute you, Anne. If you could click on the bottom left-hand corner. Thanks for your patience, everybody. We'll be with you in one moment.
There, we're unmuted. Okay, am I unmuted now?
Yes.
Okay, so I'm going to share my screen. So now I can't share my screen. See, it just keeps going over there. I'm so sorry. I'm having major technical difficulties, which didn't occur yesterday. But I'm coming, I promise. And people will love seeing Daylene, former students. And I'm just backing away from her so I don't give her the crud.
Let's unplug this and go directly into
here.
Anne?
Yep.
This is Annette. Why don't I share? I've got your slides, so I will pull those up.
Perfect.
Okay.
Thank you. Okay, this
So
still doesn't work. So I'll just tell you, Annette, when I need you to switch one. So again, everyone who's listening, I'm so sorry. My computer's just going wacky today. And no one seems to be able to figure it out, but thank you. So thanks. Okay.
I will get this here.
I know Megan, she is a lifesaver. She's wonderful. And even we couldn't figure it out.
And you can go ahead and get started while Annette's pulling that up too.
Oh, okay. Great. Oh, here we go. All right. So hopefully you're able to see this, and it's basically 101. So Professor McNulty and I are going to talk about all of these issues, but in a really fast way. So this is usually a whole semester class, and taxation is a second semester class or another semester class. So we're just going to go through it very quickly. So you'll probably have questions, and we'll try and answer those as well as we can. And I apologize for the delay. Okay, could you go to slide 1? Thank you. So we always call them the big 3 in our clinic. So we do have an elder law clinic in the school in Gonzaga on the first floor, and we do all 3 of these. We do have an elder law clinic, and it is based on age, but they prefer or put people higher who are lower income. So there is no income amount, but you'll be able to go definitely if your income is low. And then if your income is higher, they might not just have enough, people there for you. Okay, so a will, a durable power of attorney, and an advanced care directive. So these are the big 3 that we always recommend. Okay, so next. Okay, so if you don't have that, and a lot of people don't, so about 50% of the population has a will. The other 50 doesn't. But if you have no will, it'll go by what's called intestacy. And that's the state's idea of where they think that your information, where you would want your property to go. And it's actually pretty good. And so that's no problem, as long as you don't mind it going from, to whoever the state thinks it should be. And if no durable power of attorney, if you're incapacitated, a court will have to appoint a guardian, and that's a lot of work. And so get your durable power of attorney. And then if no healthcare directive, and we'll talk about each of these separately, your family will decide what to do if you are terminally ill with no chance of recovery. And so it's best to have it. Next. Okay, so what is intestacy, by the way? And you'll see that I've got a map on there, and it shows the community property states. And so we're a little different because most of the states are what are called separate property states. So whatever's acquired by me would be mine, and what's ever acquired by my husband would be his. But in community property, we take all of our earnings together, and we own half. And so you can see a little bit of a distinction. So community property law came from Spain through Mexico up to the Western states. And then you've got Wisconsin, and I have no idea why. But in any event, all of your property, if you have a spouse, is owned equally by both of you. But you can, if you want to, have a contract to treat it separately. You could also have a contract in the other states to treat your property as community property. So it's up to you. You can go by contract. Next. Okay, so wow, look at this. So this is intestacy in Washington. Usually you'll see a fairly short intestacy statute. So this is where it goes if you do not have a will. And you can see here, it's rather complex, and it's really not once you get down to it, but it's basically saying, here's the share in number 1 of the surviving spouse, that's how much they get. And it depends on whether or not you have children. So issue are children. So be sure and go home tonight and say issue, I'm talking to you. And then the shares other than surviving spouse is under 2. And so it's fairly detailed, but every state has it, and it would go where you'd think it'd go, you know, to your spouse, to your kids, that kind of thing. So each state is different. So Professor McNulty and I are going through mostly Washington, but he's got a lot of tax material that is for other states, for all of them. And so, but you'll see here, there is no federal probate. There's no federal, you know, wills or trust statutes, none of that. Each state decides on its own. And so that just becomes from the 10th Amendment, which says anything not given to the feds is given to the states. And next. Okay, so here's an example of a Washington state will. And so here's what you need. And it's not too much, but they're very particular on how this is done. So a lot of times you'll have a will that's okay, but it wasn't executed properly. And so by executed, I mean, it's got to be signed. It has to have 2 witnesses while in the presence of the testator. So that's really important. And we don't have holographic wills in Washington. So the holographic wills are defined as a wholly written will by yourself with no witnesses. So you can write your own will. You can do it on any piece of paper. You can type it, no problem, as long as you sign it. And then you need your 2 witnesses while in the presence of you. And so that creates some issues right now during COVID. And so the question would be, if somebody's on a Zoom call, would that work? Are they in your presence? And I think so. We haven't had a case on it, but I would guess so. But better to have it, you've got your witnesses signed. So we had a drive-up will signing this summer, and we had the students outside signing as witnesses, and somebody would pull up and they'd have it done. So one of the questions comes up is, if I don't have any property, why would I want a will? So why would an 18-year-old want a will? And I'll just tell you about a case where a child, I would say a child, an 18-year-old who could have had a will, didn't, of course, because who would? And she was in a terrible car accident and died. What happened was it went through intestacy. And so both of her parents, 50-50 to both of her parents. Her father had never been in her life, ever. And so that child definitely would not have wanted that to go that way. And so what the lawyer did, which I thought was really smart, is they took that person, they took the father, and he did get half because that's probate law, but then they, the former spouse sued him to get all of the child support that should have been paid all that time. So even though it seems odd to have a young person with a will, sometimes it's a really good idea under certain circumstances if you don't want intestacy. Next. Okay, what should you put in your will? So obviously all your property. And so Patrick's going to talk about if you have property located in another state, it has to be probated there. So if I had property that I owned in Illinois, I have to probate that property in Illinois. Or a good idea, I put it in a Washington trust. And so I don't have to go to Illinois and see a court there and all that stuff. I can just have it all here, and that does work. So that's really quite nice. You should put in who you want as your executor, and I would put in a secondary executor as well. So I have 2, and it's both of my brothers, and they are older than me. So at some point I may have to change who my executor is. But if that person doesn't exist, the court decides. Direction for guardianship of your children. For me, this was really important because I wanted to make sure where my children went. Disposition of the body, if you're so inclined, otherwise your relatives decide. So if it's important to you to be cremated or buried, let that be known in your will. And you can do wild stuff too if you want. So the man who created Pringles he was cremated and then had his cremains, as they call it, put in a Pringles, which was kind of amazing and awesome. You can have them go up into space. I mean, it's amazing. Okay, powers of the executor, good idea to put it down. If you don't, then there's trust law and will law of what the executor can do. And then you can put a trust within your will. So this is called a pour over trust. I have one of those. So I've got a will, and then I have the mention of a trust in there. And it's because my kids are, I wouldn't say they're young, but I wouldn't want to give them a pile of money. Let's put it that way. So I have my brother as the trustee, and then he can dole out the money until they're a certain age. And then a no contest clause, I think, is a really good idea. Some people look at it as rude. I don't at all. I think it's a fabulous idea. So you essentially say everybody gets 1/4. If anyone contests this will, they get $100. And so the person is far less likely to contest. And you might say, well, shouldn't we allow people to contest a will? Yes. So if they have a valid claim, they won't enforce that no contest clause. Next. This thing is great for everything. So if you live in Washington, this Washington legal help or law help is absolutely fantastic. It has forms. It's wonderful. It tells you exactly how to do it. And it's put together by lawyers, and it's quite good. Next. Okay, how about a farm will? A lot of people want to have a farm will, and they're pretty good, to be honest with you. They're not ordinarily state specific. They should be. And so if you buy this at Costco, and it's pretty cheap, I mean, it's $90, you know, what you just have to be careful about is that it still has to be executed properly. So it's going to have to be in writing, you know, signed by you, signed by 2 witnesses, the same thing. And so one of the things comes up in some states is because so much is printed, they don't count it as a writing. Other states look at, well, the important parts were in writing. Okay. So Governor Inslee did make some proclamations for COVID, as you're probably aware. So this allows a notary to actually take the place of your witnesses, which is nice. And the notary can appear, according to this, by video. So that's a big, big help. So you'd only need one notary, and this notary has to be the special notary, but you can find those in Washington. Next. Okay, how do you revoke? You'd think you could just tear it up, wouldn't you? Mm-mm. So you have to do it exactly like this. And so a subsequent will revoke it in whole or in part, burned, torn, canceled, obliterated. And I kind of want to obliterate my old will. I don't know, it just sounds like fun. So, but you have to do it exactly this way. And revocation of a will revokes all of its codicils. So we'll talk about that in a second. And if you have someone else do it, so if you have your lawyer do it, then they have to do it while you're there. And I think that would apply to video and at your direction. Next. Okay, codicil is essentially an amendment to a will. And so you've got here one that would not work because a codicil is required to have the very same requirements of a will. And so for this codicil to work, which is just written in, you'd have to have 2 witnesses for that. And so don't do that. Don't write on your will. It can create big problems. Next. So durable power of attorney, I think, is fabulous because it gives you, you indicate who you want to have this. I recommend one for finances and one for healthcare because it may be what my one brother is awesome in finance, my other brother is really good in healthcare. You could have the same one and you could do it all in one durable, but I like 2 just in case. And then why is it durable? Because it lasts when you get incapacitated. So that's what's nice about it. They don't have to go to court and have a finding that you're not able to manage your affairs. Next. Advanced care directive is so important. So I always say, don't do it for yourself, do it for your family. Because if you don't indicate what you want when you're terminally ill or permanently unconscious, then your family decides. And so let's say you have 4 children, and let's say they have different ideas. So 2 say, yes, I want everything done. 2 say, no, I don't. Let them know. And so my mother let us know in oral form since we were kids, honest to goodness. She'd say, I don't want to be on wires, blah, blah, blah. So, and then I gave her a form and she filled that out. So there was no question in our minds what she wanted. And you can say, I do want treatment or I don't. So it's not, you know, one person told me, well, I shouldn't do this because then they'll unplug me sooner. No, that's murder. So don't worry about that. Next. Okay, where do you put them all? Good question. Put them so that someone can find them and tell someone where they are. Some people have them with their lawyers, and you can. The only problem with that is you have to go back to that lawyer to get it. And so it's not completely ethical in some states. They don't think a lawyer should hold on to it. You should have the original. There is a will repository in Washington, which is pretty cheap. I think it's, I don't know, $20 a year maybe. And then it's filed with the state. Next. Maybe that's it. No, that is it. Oh, good. So I think I got to everything. Okay, which is good because I'm out of time. Thanks.
Okay, thank you, Anne. I'm going to share my screen. Let's see if I can accomplish this. Okay, we've got a slideshow, right? Look at that. Patrick McNulty, as Annette indicated, I am a partner with Randall Danskin in Spokane, Washington. This is a slightly more updated, a little bit out of date still. My wife, Katie, is also a 2010 graduate of Gonzaga Law School. She is a prosecutor of Spokane County. Her job's far more interesting than mine. We like to think of Gonzaga as a very high-priced matching service. It's worked out well for us. So our kids, Quinn and Margaret. Quinn is 8 years old, just turned 8 last weekend. He is in 2nd grade and Margaret is in 1st grade. I've got a lot of stuff in these slides. We're going to burn through it. Suffice it to say that this is not legal advice. I'm not giving you legal advice. You could spend an hour, and oftentimes when I meet with clients, we do spend an hour or more talking about one piece of what we're going to cover. It just depends on what your needs are. The takeaway is make sure to consult with your estate planning attorney. Whoever it is, or if you don't have one, get one. Consult with them. It's easy to think, oh, I've got a simple estate. Katie and I have simple estates right now, right? We've got 2 kids, first marriage, don't have a ton of assets yet. But the fact of the matter is our situation is going to be different from Anne's. It's going to be different from yours. So make sure that you consult with your estate plan attorney and make sure that you get your needs met. They asked me to talk briefly about a will alternative. Depending on what state you're in, you've probably heard of a revocable living trust. If you're in California, this is the only estate planning tool you've heard of. They shy away from wills like they're toxic, and that has a function of kind of what the cost of probate is in California. Probate's the process by which you file the will and get appointed. But a revocable living trust, revocable meaning it can be revoked, is different from an irrevocable trust. It's used as an alternative to a will. So it's focal point of your estate plan. Oftentimes we may have a will that pours back into the trust. But it's handy for a number of reasons. One, if we don't want to have to go through probate, and you may still go through probate with a trust, as we're going to talk about. But it's handy if we have property in multiple states. If I have property in Washington, Idaho, and Arizona, An easy way to avoid having to have probate done in each of those states to clean title to that property when I pass away is to have the property in a revocable trust. So probate avoidance, certain states have very expensive probate processes and long processes like California, Hawaii. Once again, the idea behind a revocable trust, my in-laws come from California, they have a revocable trust. The idea behind it is you can avoid the cost and expense of the probate proceeding. Privacy is another consideration. Important to note though with these, and I have clients come in all the time, a lot of clients come in from out of state and they say, you know, we want a revocable trust and we're going to save taxes by having a revocable trust. Well, the fact of the matter is your revocable trust does the same thing that your will does. It doesn't, it can save taxes. The planning considerations that we can use with a revocable trust are the same as we can do with the will. So that just when you think about revocable trust, don't think tax savings. You can get there with the will, you can get there with the trust. You know, it also doesn't avoid having to file an estate tax return. We may avoid probate, but if I am over the estate tax threshold in Washington or federally, I'm still going to have to file a return with the IRS or the Department of Revenue of the state of Washington. So once again, kind of a misconception out there. You know, for those of you that don't know what a revocable trust is, just think of it as another, it's like your alter ego. It's a vehicle that holds your property. Yeah, you set it up, you have a trust agreement. So instead of a will, you're going to have a document called your trust agreement. You are the trustor. The document is revocable, meaning you can take property out, you can put property in, you can change it while you're alive. Much like your will, the document's going to specify what happens when you die. If you're married, it's going to specify what happens once you're dead and once your spouse is dead. It's going to set forth where your property goes once you're gone, once your spouse is gone. Selection of trustee is key. With a revocable trust, once again, if it's properly funded, your assets are in the trust. And so instead of a power of attorney acting on your behalf financially, you're going to have a trustee selection mechanism in the trust that's going to specify who's going to manage the trust affairs. Typically, you're the trustee, but as you get older or if you have some sort of incapacity event, it's important to know who's going to be the backup, who you select. Typically more expensive to set one up than getting a will in place. They may save cost on the back end. The idea, once again, is if we get all the property into the trust, we can avoid probate. And on the back end, we can save costs on the probate proceedings. I'd caveat to that, in Washington, probate is very informal. There's not a lot that gets filed with the court, and it's pretty inexpensive. So I think more often than not, our clients come out ahead from a cost standpoint. If they purely have Washington property, they come out ahead probably with a will-based structure, and we'll tell them that. You know, I'm not trying to get rich selling trusts or selling wills. It's just that for a Washington resident, oftentimes will is going to be better than trust. The other key thing to think of when you have a trust is you have to fund it properly. If you come in, or if you have a trust in place and you're just gung-ho that you want to avoid probate and you want everything to be secret, that's great. If you forget to put a piece of property into the trust, and by that I mean when you buy the lake cabin, if you take the property in your name, you've just taken the trust and undone the whole purpose of it, because now the property is in your name. If you die, we're going to have to file probate in the state in which you have that property, so that we can then transfer the property into your trust. So make sure you fund it. That's probably the number one mistake that we see with those, is people form them, they're really excited about them, and then they forget about them. And so we end up still doing a probate, and you've got kind of this mismatch of having a will on the one hand and your trust on the other hand. Let's talk about, and like I said, we're going to burn through this stuff, some tax, non-tax considerations. You know, I have an LLM in tax. I get really excited talking to my clients about tax. I'm pretty sure that their eyes kind of glaze over when I start talking about the state and the federal estate tax and the GST tax. All that to say, don't let my enthusiasm or your estate plan attorneys, don't let that tax tail wag the dog. That's the kind of the famous statement. More important than taxes, you're going to be dead. So, you know, really, you don't care. You do care that you may not want to pay this money over to the government. You won't be around. So more important is just, what are you doing with your assets? Who is getting them? You know, is it your spouse, your kids? Are we giving them to charities, Gonzaga? other family members. Do we have special considerations for the recipient? Quinn and Margaret are 6 and 8. I don't want them getting assets outright. That'd be disastrous, especially for Margaret, who would spend it on Barbie everything. What is their financial ability? What's the risk of loss? Are they a spendthrift? Is there a chance of bankruptcy? Are they in a bad marriage? Do they have special needs? Are they on governmental assistance? I have clients come in, they have a child that has, some disability, or maybe the child has drug and alcohol abuse history. Maybe the child is on governmental assistance. These all have to be taken into consideration when we're talking about what are we going to do? If I give them $1 million, that could be catastrophic. Let's talk first about planning with spouses. If you're married, what happens on the first death? And then what happens on the second death? This is typically the conversation I'm going to have with my clients when they come in. Outright bequest is simple. With a will or trust, we call this an I love you will. I love you, Katie. Here's everything I've got. Very simple. Maybe not tax efficient, especially in a state like Washington that has its own estate tax. That piece is beyond the scope of this discussion. Just know that if you're in Washington, if you're in Oregon, you're in Hawaii, any of these states that have state level estate tax, you really need to be talking to an estate planning attorney because there are nuances that apply that may not apply from a federal standpoint. Pro and con, if it's an I love you will, outright bequest, surviving spouse controls disposition of the estate. That can be good. I love Katie. I trust her. I know that she'd do right by her kids. Same token, that could be bad. If I think Katie's going to remarry and cut Quinn and Margaret out of the will, maybe I don't want to leave things to her outright. And I'm saying that kind of tongue in cheek, but maybe more to the point, maybe it's a second marriage or a third marriage. We have a blended family. I want to make sure my kids are covered once, I want to provide for my spouse, but then I want to make sure that my kids are covered after my spouse passes away. Also, if Katie has the assets outright, maybe someone sues her, maybe she files bankruptcy, maybe she goes through a bad second divorce. These are all considerations that might mitigate towards putting my assets, and in Washington, it's going to be my half of our community property and all of my separate property into a trust for her benefit. Once again, the trust would specify on what terms she gets the assets. Typically, we would use a trust, or you see the term disclaimer structure. Disclaimer means I give everything to Katie, but she can disclaim into a trust. Pros and cons of having a trust for a spouse. My will or my revocable living trust is going to control what happens to my half of the estate. So trust for Katie might say she gets the income for life. And when she dies, it's split evenly between Quinn and Margaret, which is what I would want to see happen. There's asset protection. For my half of the estate, if it goes in trust for Katie, it's protected. She files for bankruptcy, she gets sued, that asset's going to be much better protected from creditors or predators than if Katie has all of the assets outright. Also, potentially greater tax efficiency, especially where we're in the state of Washington. Con, it's dead hand control. I'm controlling what happens with the asset. Cost of administration, you have to file tax returns for the trust. So kind of pros and cons to think about. Second death, what happens with the kids? Once again, trust or outright. Outright is very simple. May not make a whole lot of sense if it's Quinn and Margaret and they're 8 and 6. I don't think they can legally even hold title to property. Tax considerations, if the trust is the recipient, trust is a taxpayer, it's going to likely have higher income tax rates than Quinn, Margaret would. So maybe we have to carry the income out to them to get deductions. With the trust, what are the terms? And once again, it's not one size fits all. Do the recipients get the income for life? Is it discretionary? The trustee, the person that's charged with holding the money and distributing it, do they have discretion over how they use the money for Quinn and Margaret's benefit? Can the money be used as just for education? Can it be used for Quinn to buy a Porsche? Probably wouldn't be a great idea. 18-year-old Patrick would have thought that was a great idea. 36-year-old Patrick thinks that's not a bad idea, but nonetheless, what do they get the money for? Can it be used to buy a home or put a down payment on a home? what age do they get the money at? I've got clients that come in and they say, hey, my kid's at 25, I want them to get everything. And then I've got clients that say, my kids are idiots, I don't want them to get money ever. Who should be the trustee? Can the beneficiary be the trustee? That's kind of like having the fox watch the hen house. Do we have a family member? Do we have a grandparent? Now the grandparents, obviously when we have younger kids, that's a pretty easy one, but you got to be forward thinking, right? My mom is, she's 60. My in-laws are in their early 60s. If I have a trust that continues until Quinn and Margaret are 45, odds are pretty good they're not going to be around. So we need to be thinking about who the trustee is, who the backup is. One other consideration, and we typically recommend this, is with the trustee, when we have minor children, have someone be separate from the guardian. So a guardian's going to have the children and take care of them day to day. Oftentimes, if it's not a parent or maybe a sibling, or even if it is a parent or sibling, it might be good to have someone else manage the money so that we have kind of a separation of church and state, if you would, or you're just not worried that the guardian is spending the money frivolously. You've got someone watching that money so that it's there for your kids or your offspring when they get older. Federal estate and gift tax, we're going to fly through this, but just know that we take courses on this. I spent a year in tax school on this. Basically, from a federal standpoint, the feds are going to tax you if you die with or give more than $11.5 million. 11.58 this year, it goes to 11.7 next year. It's a ton of money. Most of my clients in Spokane don't have that problem. We do have clients that have estates that are larger than that. That's per person. So with a married couple, you're going to have 23 million of exemption. All that to say that if I exceed that by gift or estate, we have a 40% tax. And there are certain exceptions, gifts to charity being one. I don't pay tax on any amount gifted to charity. Gifts to spouse typically also are exempted. Something interesting, with the election results, I pulled Biden's campaign proposal. Who knows where this is going to go? A lot of it's going to depend on what where the Senate is at moving forward. But according to taxfoundation.org, Biden campaign proposes to move the exemption back to $3.5 million per person, top rate of 45%. And I think the more pressing issue is the concept that under current law, Code Section 1014B, when someone dies, their assets step up in basis to fair market value. So it's a very easy example. If I were a genius and I bought, 1,000 shares of Apple back in 2005 when it was $3 a share, and now it's worth $110 a share and it's split a couple times. If I sold that stock, I would pay capital gains on the difference, right? If I die with it, 1014B gives my estate and my beneficiaries a huge tax benefit in that the asset steps up in value to fair market value. So if I die with that stock and Quinn and Margaret turn around or Katie turns around and sells it, the stock has a fair market value basis for purposes of computing any capital gain. Tax proposal from Biden, they might want to see that go away. We'll see what comes of that. But just under current law, that's a huge planning point. Most people don't have enough money that they have a federal estate tax problem. The basis increase, though, is a great tool for most people because, if mom and dad have a couple $1 million and they die, I get an adjusted fair market value basis. Generation skipping transfer tax, just know that this one's out there. It's kind of an interesting one. The feds want to get their bite of tax at every generational level. I believe the impetus, and don't hold me to this, from tax school was like the Rockefellers. They want to tax you at every level, right? So if grandfather tries to transfer assets to grandchild, that's a party more than one generational level below him. You're going to potentially implicate the GST tax. It's a 40% tax on top of the federal estate and gift tax. You have the same exemption. So grandfather, grandmother could give up to $11.5 million before they would implicate the GST tax. When they burn through that, it's also a 40% rate of tax. That's on top of the gift tax. So as a real scary hypothetical, if grandfather has used all estate and gift exemption amount and has used all GST exemption amount, if he wants to give $1 million to grandchild, you're going to pay 40% gift tax on that. You're going to pay 40% GST tax. And then believe it or not, you're going to pay tax on paying the GST tax. So it ends up being like a $960,000 tax to give grandchild $1 million. Pretty crazy. State level estate tax. This is the one that I think catches more people, especially in Washington, Oregon, Hawaii. This map, I believe, is current. So, take a look at it. Washington, Oregon, Hawaii all have state level estate tax. The exemption amounts are a lot lower, so they apply. Federal exemption used to be really low. It's gone through the roof, not all that applicable anymore. State of Washington, Oregon, Hawaii have much lower thresholds. And so a lot of our planning in these states centers around that exemption. Now, Washington, it's 2.2 million. So, a lot of people, especially on the west side, you own a home in Seattle and you might be over that exemption amount. The rate is lower. It starts at 10% when we exceed that exemption amount and graduates up to 20%. And I'll skip down. So let's just take, a widower has a $5 million estate. They want to leave it to their kids. They've never made any lifetime gifts. They don't have a federal estate tax problem. Federal estate tax exemption is 11.5 million. They don't have a problem. From a state standpoint, 5 million, if they're leaving it to their kids, is over the 2.2 million exemption. That means that they have 2.8 subject to tax. They're going to pay state of Washington tax on that. Very easy planning pointer we're going to talk about is the fact that Washington, and I believe Oregon, and I'm not sure about Hawaii, but a lot of the states that have a state tax don't have a gift tax. So in the state of Washington, that same individual could avoid the tax by just gifting down to the exemption. Bill Gates could give all of his money to me. Won't happen, would be nice. But if that happened, Bill Gates would pay no tax to the state of Washington. He would pay a lot of federal gift tax, might even pay GST tax. I'm not sure how much younger I am than Bill Gates. But there would be no state level estate tax. So it's a huge planning pointer in Washington and probably in Oregon. I'm not licensed in Oregon, but like I said, very big planning pointer. We're doing good on time. Some planning considerations. Annual exclusion gifts. I have clients come in all the time that assume that, that you've heard kind of annual exclusion gift. That's $15,000 per year per recipient. Client comes in and says, well, I don't want to give over that because it's taxable. That's not true. The IRS just says we don't track any gift under $15,000. So I could give $15,000 to Quinn and Margaret and Katie. I could give 15 to anyone I want, per person per year per donor. They don't track it. If I go over that, I've got the exemption amount of 11.5 million. They track that. I have to file a return. I don't pay tax until I've burned through the exemption. 529 plans, if you haven't heard of them, talk to your financial advisor, your estate plan attorney. Great tool, especially if you have young ones or grandchildren looking at college. You can front load 529 plans with up to 5 years of annual exclusion gifts, $75,000 per recipient per year. Let's see. When we're making gifts, consider the basis of the gifted asset. Once again, if we're trying to gift down for estate tax purposes, that's great. Your mind is in the game. But be mindful, state of Washington's top estate tax is 20%. Top state of estate or state of Washington estate tax 20%. Top capital gains tax rate is 23.8%. So in my Apple stock hypothetical, if I gave Quinn and Margaret all my Apple stock thinking, wow, I'm going to reduce my estate, great. Maybe I've saved some state of Washington tax, but when they sell it, they're going to pay up to 23.8% in capital gains tax. So you have to be mindful of that disconnect, right? Gift higher basis assets if you can, so that we don't have the built-in tax problem that goes away when we die. Just know that, with higher net worth clients, a lot of times, especially in Washington, where we're trying to gift down to the estate exemption level, Washington doesn't tax the gift. We have 11.5 million per person federally that we can work with. So we're making gifts, filing gift tax returns. We're trying to smartly leverage that exemption amount. Believe it or not, if you structure something right, you may only use $1 million of exemption to give away $2 million of assets, depending on how the discounts you might get with that asset work. I have clients that even make gifts over the exemption amount. So they make gifts that are going to incur tax, but it's tax efficient to do so. Once again, that's a very specific situation you're going to be talking to your advisor about. Charities, great gifting recipient. Gifts to charities are not taxable. Bill Gates gives his entire fortune away to charity and there's no tax due. Neat thing at the Washington LLM program, we took our charitable class. We had some attorneys from the Bill and Melinda Gates Foundation teaching the class. Fantastic class, great to get their perspective. Inter vivos gifts to charity, that just means a gift made during life. Also a great tool. Not only does it get the property out of your estate, you don't have estate or gift tax consequences, but you can also get a deduction from your income taxes. We're going to touch on kind of two important things, retirement accounts and insurance. Retirement accounts are a huge asset, and they're becoming more and more so for our clients. A huge asset. Kind of the takeaway, and there's so much to unpack, but the takeaway, make sure the designations you have on that account sync up with what your estate plan is. You'd be amazed how many times I have a client come in. They've got the will all sorted out. They've got one son that's got a terrible drinking problem. They don't want him to get anything. And I ask to see the designation on their retirement account, which is a massive part of their estate. And we get the account, and oh, by the way, they've designated all 3 kids equally. So you need to make sure that you sync those designations up, because that retirement account is going to pass pursuant to designation, not necessarily pursuant to your will. Charities and retirement accounts. Charities are a great recipient. You can make distributions if you're of distribution age, and once again, talk to your financial advisor, talk to your estate planner. Once you reach minimum distribution age, charity is a great recipient for minimum distributions. You get it doesn't count against your income. You get to do some good with the gift. You can leave a portion or all of your IRA to a charity. Once again, that IRA distribution, when it comes out, if I leave a $1 million retirement account to my wife or to my kids, when they pull that money out, they pay tax on that. If instead I leave it to charity, I don't pay estate or gift tax. It's really efficient. And on top of that, the charity doesn't pay income tax. So it's an incredible, if you're charitably inclined or you have charitable intentions as part of your estate plan or tax planning strategy, using an IRA and a charity is a great tool. So just file that one away. One caveat, Roth IRAs, where you've already paid the tax, not as good a tool because you paid the tax. When the distributions come out, they're not taxable. So the considerations are a bit different. I'm going to touch on 2 more things and then we'll take Q&A. Life insurance, if you're young and you have a family, get it. It's so important. You look at, a lot of us, and I don't know the average age on this call, but, I'm 36, going to be 37. I've got a wife and 2 kids. We've got a lot of things going on. We're paying for a home. We're still paying off law school loans. I've got 2 kids I need to put through college. The idea of life insurance, it's cheap. Term life insurance is really cheap. I don't sell it. I'm not trying to sell it, but it's cheap. And the idea is if something happens to me, it's there to help replace my lost income. Something near and dear to me, we lost my dad when I was 19. My mom was 43 and my sister was a sophomore in high school. I was in college, and they had done some prudent planning with insurance, and it was just, I'm getting emotional, but it was nice that we didn't have all the financial pressure of worrying about, can I keep in school? Can you pay for things? We got to mourn dad and not worry about it. So it's a hugely important piece. Like I said, I didn't envision getting emotional about this, but just really think about it. When we're talking about insurance, also be mindful, it's included in your estate if you're not smart about it. So if I have $2 million of life insurance that goes to my kids, and it's term insurance I'm just paying for, great, but I also may create an estate tax problem. So be mindful of that. If you have enough assets such that might tip you over the estate tax threshold, think about using a trust to structure your life insurance. We have a lot of higher net worth individuals that life insurance is a key component of their estate plan. And we're using what we call an irrevocable life insurance trust to get that insurance paid, but also keep it out of their estate. So once again, that subject that you could spend hours talking about, carefully structure it, talk to your estate plan attorney, but very important piece of your estate plan. I think the slides will end up being posted, so I'm going to skip through. One thing with transfer on death designations, just know that a lot of times when you set up a bank account or a brokerage account, they're going to ask if you want a TOD. that can be great. So I'd specify Katie as a TOD on our bank account. It can also wreak havoc. So if I'm working with you to craft an estate plan that's tax efficient and you set up a TOD on $1 million brokerage account, I'm going to be really ticked at you. I'm teasing kind of, but it can really, really mess up what we're trying to do. So just make sure that you talk with your broker on the one hand and you talk with your estate planning attorney on the other hand, and they sync up. For the right individual, smaller estate, they work really well. I die, everything goes to Katie. We don't have an estate tax problem. It's easy, but just make sure that you talk about it before you do it. This one's fun, but we don't have time, but be mindful if you have a family lake cabin or legacy property, maybe not the best idea to leave it just outright to the kids. You might do something with it like an LLC or a standalone trust. This hypothetical is fun. We won't talk about it. Two things they wanted me to talk about really quick. How to pick a professional. Attorneys are, and I'm an attorney, so I don't think this, but other people, it can be daunting talking to an attorney, right? They know something that maybe you don't know. Make sure to interview us. Put us through our paces, get someone that you have good rapport with. View this as someone you're going to have a long-term relationship with, CPA, financial advisor, primary care physician. Make sure you like them. Interview them. Most of us will give you 30 minutes of our time free to talk to you and make sure it's a good fit. Make sure you understand their fee structure, and don't cheap out. If you're going to pay for it, get what you pay for. Trying to save $500 to use someone that you don't trust, I personally wouldn't do it, but to each his own. In terms of cost, it's going to be all over the map. I've seen simple wills, $500. I'm not representing that I can do that for you at $500, but just know that, it's not that expensive. You can find good attorneys that'll do work for you pretty reasonably. Moderately complex plans might be more money. Complex, typically it's going to be by the hour. You won't get a flat rate. But as a hypothetical, and this is one you see every day, proper planning, maybe an estate plan attorney saves you $5 million. $20,000 spent structuring that plan probably is a pretty good investment. With that, I thank you for the opportunity to talk to you. I think we'll open it up for questions. I went a bit long, so Annette, turn it back over to you.
Yes, can you hear me, Patrick?
Yes.
And okay, we have some good questions here, so I'll try to get through these. There's a couple of them on codicils. When to use a codicil versus redrafting your will, and how do you go about setting up a codicil?
Can't take that one.
Okay. Yeah, so, Patrick, you can talk too, but Patrick could say when it's a better time to use a will rather than a codicil. My theory is if you're just adding a little bit or changing something like the executor or, the portions that are going to children, then you can use a codicil. If you're doing a big change, you'd want a new will. The codicil has to be executed exactly like the will is. So you have all the formalities. You can't just write something in on your will. It's a really bad idea. And essentially, like I said, if you have to do a lot, then do, a new will. If you have to, just a couple of little changes, do a codicil. But they're just as formal in terms of execution.
Yeah, I was going to add on to that. If you have recently done your estate plan with an attorney and continuing representation, everything's in Word now. So it used to be that a codicil, save the time of having to retype the will. If I'm your attorney, we've got it in Word. I'm probably just going to have you sign the will because it's just as easy for me to insert into your Word document the change you want. So that's the one qualification on that is that, with Word now, it's pretty easy either way to change it.
Okay, next question. Does the state estate tax apply based on where the decedent passed away, where the assets, real property are located, or when the person receiving the inheritance, or where the person receiving the inheritance lives?
That's a great question. It's a fantastic question. It's going to vary state by state. Washington, Oregon, Hawaii. So if I die a resident of Washington, and I think the other states work the same way, Washington takes the standpoint that they can tax me on all of my real property in the state, as well as all of my intangibles, so all my stocks, bonds, bank accounts. They don't tax me, although they have kind of a roundabout way of doing that, on out-of-state properties. So my lake cabin, I don't have one, but if I did, in Idaho, is exempt from state of Washington tax. The same would be true. Now the inverse, let's say I have property in Oregon. Oregon has an estate tax. I die in Washington. Once again, Washington will tax me on my real property in the state and intangible property in the state. Oregon would potentially impose its own estate tax on me as an out-of-state resident, but only on the Oregon portion of my property, the Oregon real property.
Okay, can you address DocuSign applications for these topics? That's pretty popular these days, using DocuSign.
Yes, and it depends on the state that is actually using it. And so I think you can hear me, hopefully. So some states don't treat it as a signature, other states do. I think they're generally okay as long as it's, done properly. So I'd be a little bit wary, but should be fine.
Okay. And this question might be for you. What is the advantage of putting your will in a repository?
The only thing is sometimes they're hard to find. And so especially if you die suddenly, you haven't told anyone where your papers are. It might be in your safe deposit box, but no one else has access to your safe deposit box. So usually people think that's a great place to put something, but the problem is somebody has to have a key and access. And so that slows down the process. I think the best idea is let people know exactly where it is and make sure that you show them. And I know that's the problem. It's hard to talk about death, and sometimes your children, your spouse do not want to talk about it. So I just told my family it's in this drawer, in this cabinet, and that's where everything is, so they know where it is. The depository is nice because if you can't find it, if your executor is unable to find it, it's always there with the state. But it does cost something. It's not very expensive, but it does cost.
Mm-hmm. Okay. Some of these questions we will address actually at the following of the webinar, where we will provide access to many of these resources. Here's one question. I wonder if you can talk a bit about estate planning devices you would recommend to plan for cognitive impairment, not severe enough to qualify as legal incapacity.
Yep, and so I happen to see Washington is many times ahead of other states in a lot of things. And they actually have a new type, and it just came out, but it's a new type of power of attorney for when somebody has dementia. And so you're not completely incapacitated yet, but you are able to, you're not able to do, say, all your billing and that kind of thing. So my mother had Alzheimer's, and you lose it a little bit at a time. And so that was helpful. So my brother had a power of attorney, just a regular power of attorney that worked during that period of time. The durable power of attorney is better because you can act for that person, and as they go into incapacity, and you don't exactly know when that happens. Sometimes it's not that clear. And so it goes all the way through. But they do have now some ideas about what to do if you have dementia in your family.
Okay. I know we're right at the top of the hour. We do have some additional questions, and our hope is that we can actually get the answers out as part of our follow-up. So let me just assure everybody that we will be sending a follow-up to today's email. It will include a recording. It will include many of the resources that have been shared here. And along with that will be a survey. So we would encourage you to fill that out to just let us know how we did other than the technical difficulties. We really appreciate your feedback and it helps us with future programming. Just know we will get back to everyone and we appreciate you spending your lunch hour with us. And Anne and Patrick, thank you both. We really appreciate your time today too. And we just want to wish everyone, stay well and take care and go Zags. Thank you.
Thanks.